Well, hello and welcome to another Sunday morning coffee with Dr. Childress here. So today I'm going to be discussing an email that I wrote to an attorney client, a parent client, that contained my recommendations. And I looked at the email and said, I can send this to a lot of attorneys and a lot of parents regarding my recommendations surrounding the situation. This particular situation involves a GAL and potentially two therapists. People are kind of considering which therapist to land on. And I just redacted the names of the therapists, but that's a standard kind of thing that many families face, a GAL and a couple therapists. If this don't have a GAL in your situation, well, just adjust the email. Everything about treatment remains the same. So, excuse me. So this is a transcript. So I basically cut and paste and put it over into this email recommendation to everybody out there. So to begin with here, this is the way I started. In preparation for our meeting, let me share some relevant information. So if anybody wants to get a monthly or, first of the month consult with me in preparation for our meeting, here's some relevant information. Now, there's multiple parties involved. A GAL and court are involved who have decision-making influence regarding treatment. Navigating the legal system is the role of the attorneys. My role is as a doctor in the healthcare system, psychological and psychiatric healthcare. So based on the reported symptoms, my concern is that the DSM-5 diagnosis is 297.1 delusional disorder, shared persecutory type, and V995.51 child psychological abuse. And then I'd have a rule-out diagnosis of a factitious disorder imposed on another, and a rule-out of 995.51 spouse or partner abuse psychological. So those are my concerning or considered diagnoses based on the symptoms. Now, attached are a set of diagnostic questions that I need answered from the involved mental health providers in order to provide appropriate consultation to you, the father and his legal team, regarding treatment. And so this is the attachment. I just pulled this from the attorney resource section of my consulting website. So I went over there, pulled this. These are the questions to be answered. Basically, it's a path A. Path B is a targeted parent abusive. That's your path A, yes or no. Is the targeted parent abusing the child in some way? If yes, specify the type of child abuse. Or is the allied parent, that's path B, is the allied parent abusive? Is the allied parent psychologically abusing the child by creating a shared persecutory delusion in the child? Yes or no? I need that information from the involved mental health professional. Allied parent is abusive. Is the allied parent psychologically abusing the child by creating a false, factitious attachment pathology in the child for secondary gain to the parent? I need that. Please, somebody tell me, is this going on? And then third is spousal abuse. Is the allied parent using the child as a weapon of psychological spousal abuse of the targeted parent? So those are the questions that need to be answered. Desire for treatment. A foundational principle for all doctors is diagnosis guides treatment. There appears to be a desire for treatment, and Dr. So-and-so has been offered as an option. My question as your consultant in clinical psychology, as a doctor, is treatment for what? What is the professional level diagnosis being treated? Is it a shared induced persecutory delusion and child psychological abuse, DSM-5 297, DSM-5 V995.51? Okay, if not, why not? Because the symptoms sound awful good, close to that. So I want to is that the diagnosis? Or if not, why not? And what is the diagnosis? I need that information to provide consultation. If so, the initial treatment plan, if it's the delusional disorder and child psychological abuse, the initial treatment plan is called a safety plan. And that's true with all dangerous pathologies. If we have child abuse, we don't start treatment. We start a safety plan to make sure everybody's safe, and then we move into the treatment plan. So then the initial treatment is called a safety plan based on the child psychological abuse diagnosis, DSM-5 V995.51, that is the result of the shared induced persecutory delusion, DSM-5 297.1. So these are just standard DSM-5 diagnoses, please. Can somebody just get me an answer from the involved mental health professional regarding the DSM-5 diagnosis of what's going on? In healthcare, this is where I start to explain things to the attorney and to the parent, the dad, and just everybody. In healthcare, we do not start treatment with 6 rounds of chemotherapy. We start with the diagnosis of cancer. We don't start with the treatment of insulin. We start with the diagnosis of diabetes. Okay, that's true throughout all of healthcare. That's sort of foundational. I understand everyone's desire is for treatment. Treatment of what? The treatment for cancer is different than the treatment for diabetes. And if we treat cancer with insulin, the patient dies from the misdiagnosed cancer. Doctor, I have a pain in my leg. Doctor, I'm going to order 6 rounds of chemotherapy. Why, doctor? Do I have cancer? I don't know if it's cancer or not. I don't diagnose what the problem is. I just prescribe chemotherapy for everything. Would you like to schedule your first round of chemotherapy for this Thursday? Is that how any of actual real health care works? No. What happens? Doctor, I have a pain in my leg. Doctor, I'm your primary care doctor. Let's get a consultation from an orthopedic doctor who specializes in those types of disorders. That's what happens in real healthcare. That is what needs to happen in the family courts. You got an attachment pathology, you got a child. Well, let's get it out for a diagnosis from somebody who knows what they're doing. Diagnostic process. This is from Improving Diagnosis in Healthcare from the National Academies of Sciences, 2015. From Improving Diagnosis. The working diagnosis may be either a list of potential diagnoses called a differential diagnosis or a single potential diagnosis. Typically, clinicians consider more than one diagnostic hypothesis or possibility as an explanation for the patient's symptoms, the differential diagnosis, and then will refine this list as further information is obtained in the diagnostic process. So that's what we want to do. We want to put all the diagnoses on the table and then collect information to kind of organize what the diagnosis is lining up to be. So here again, from Improving Diagnosis. As the diagnostic process proceeds, a fairly broad list of potential diagnoses may be narrowed into fewer potential options. There's your path A, path B for a child rejecting a parent. You got 2 choices. A process referred to as diagnostic modification and refinement. As the list becomes narrowed to 1 or 2 possibilities, the diagnostic refinement of the working diagnosis becomes diagnostic verification, in which the lead diagnosis is checked for its adequacy in explaining the signs and symptoms, its coherency with the patient's context, physiology, risk factors, and whether a single diagnosis is appropriate. So that's what we do. We start with all the possibilities on the table. This is throughout healthcare, all your doctors, everywhere except the family courts, where you put all the diagnosis, possible causes on the table, and then you collect information, and some will rule in, be supported, some will rule out. And that's what we need to be doing. Continues from Improving Diagnoses. Clinicians may refer to or consult with other clinicians, formally or informally, to seek additional expertise about the patient's health problem. The consult may help to confirm or reject a working diagnosis, or may provide information on potential treatment options. So if you have a consultant, Dr. Childress, they should just consult with me and talk with me about what the diagnosis might be, and that's how we work collegially within professional healthcare, except the family courts. So clinicians, the consult may help confirm or reject a working diagnosis, or may provide information on potential treatment options. Clinicians can also recommend that the patient seek a second opinion from another clinician to verify their impressions of an uncertain diagnosis, or if they believe that this would be helpful to the patient. That's an incredibly low bar for consultation. The reason, let me pull this up. The reason we consult at such a low bar in healthcare, it might be helpful. So I recommend you get a second opinion on that. Throughout all of healthcare, all doctors, oncologists, primary care physicians, podiatrists, everybody, you want a second opinion, get a second opinion on it, except the family courts. And the reason we get a second opinion is because it elevates the quality of healthcare services being provided. And so that's why it's recommended by the National Academy of Sciences, Improving Diagnosis in Healthcare. Get a consultation. But in the family courts, everybody fights about everything. We should allow each litigant parent to appoint their own consultant and then get a 3-doctor assessment team. So you get the person doing it, and each person can get a consultant they like, and you put together your treatment team for a very severe pathology. So mandatory, required ethical standards. These are mandatory, required. Psychologists are not allowed to treat pathology that is beyond the boundaries of their competence. That's standard 2.01. Mandatory, required, that they are not allowed to treat pathology beyond the boundaries of their competence. Standard 2.01, psychologists provide services, teach, and conduct research with populations and in areas only within the boundaries of their competence, based on their education, training, supervised experience, consultation, study, or professional experience. Note that consultation is within 2.01a. Standard 2.01, boundaries of competence. C, now that was A. This is subsection C. Psychologists planning to provide services, teach, or conduct research involving populations, areas such as attachment, delusional thought disorders, techniques such as a mental status exam of thought and perception, or technologies new to them, undertake relevant education, training, supervised experience, consultation, or study. Here is 2.01, boundaries of competence, subsection D. That was A, C, now we're at D. When psychologists are asked to provide services to individuals for whom appropriate mental health services are not available, and for which psychologists have not obtained the competence necessary. That's what we have in the family courts. We don't have competent mental health services in attachment, family systems, delusional thought disorders, factitious disorders, child abuse and complex trauma. You have to be competent in all of that. It's not okay to be 30% competent in heart surgery. No, your patient's going to die. You need to know what you're doing. And so in situations where services are not available and psychologists have not obtained the competence necessary, psychologists with closely related prior training or experience may provide such services in order to ensure that services are not denied. That's what we have in the family courts. If they make a reasonable effort to obtain the competence required by using relevant research, training, consultation, or study. Okay, so they're not allowed to just be incompetent. Even if they're coming in an emergency situation, they have to take reasonable steps to ensure their competence. So a child rejecting a parent is an attachment pathology, i.e., a problem in the love and bonding system of the brain. Neither Dr. A or Dr. B are competent in the treatment of attachment pathology. In both Dr. A and Dr. B should seek consultation in attachment pathology treatment before either doctor begins treatment of severe attachment pathology. That's required. That's mandatory, required of those psychologists who are involved in this matter by the APA Ethics Code. If Dr. whoever were to conduct treatment of a severe attachment pathology, i.e., disorganized attachment, the child has no organized strategy to bond to the parent, he should seek consultation with a professional knowledgeable in attachment pathology, such as Ed Tronick, Lyons Ruth, Fonagy, Childress, noting that doctors Tronick, Lyons Ruth, Fonagy, etc., are not competent in personality disorders, family court pathology, and delusional thought disorders, while Dr. Childress is. Would you want your open heart surgery conducted by a cardiologist or a podiatrist? Would you want your foot surgery conducted by a podiatrist or a cardiologist? We need to practice within the boundaries of our competence. And if we're extending out, seek consultation or training on that. Throughout healthcare, competence is required because incompetent doctors hurt people. That's why ethical standards 2.04, 2.01, 2.04, and 9.01 exist. And that is why they are mandatory, required for all psychological doctors. I can't believe I'm explaining this, but I am, because it's so foundational to healthcare to have competent doctors, and you'd want open heart surgery conducted by a heart surgeon, not a podiatrist. Attachment pathology and Dr. whoever. You will not find any therapist with the necessary competence in attachment pathology and delusional thought disorders and family court custody conflict and personality disorder pathology, child abuse and complex trauma, family systems pathology. But let's just focus on those top three: attachment, delusional thought disorders, and family court pathology. You're not going to find anybody who has that competence. Attachments, early childhood, delusions or schizophrenia, and the family courts are the family courts. So those are three disparate domains. I have competence in all three, but you're not going to find anybody else who has that domain of competence, plus child abuse, plus family systems. So this is the result. Your problem here is the result of a larger systemic problem regarding forensic custody evaluations overall. Now, I can explain the cause, I can explain the solution, but that doesn't help you in your situation where you need treatment now when there is no competent treatment available. None. Emphasize that. I cannot solve that problem. There is no competent mental health services in the family courts, competent in attachment, competent in delusional thought disorders, competent in the family courts. So if you go get the attachment knowledge out of somewhere else, not the family court, they're not competent in the family court and what's going on. If you get it from the delusional thought disorders, you pull in schizophrenia or something, they're not competent in the family courts or with attachment pathology. And so there's nothing. Now, what should happen? 2.01, boundaries of A, 2.01C, and 2.01D. They should be initiating the consults to become competent. Anybody who's working in the family courts. So, doctor, whoever, is required, mandatory, required to consult pursuant to standard 2.01C and D regarding attachment pathology and 2, the diagnostic assessment and treatment of delusional thought disorders, and potentially on personality disorder pathology, potentially on child abuse and complex trauma, potentially on family systems. So you can get 4 or 5 different consults. You get me as your consultant, and why aren't they consulting with me? I don't know. They're required to consult because they're not competent in the pathology. Because there is no competent mental health services available in the family courts, Dr. So-and-so is allowed to provide treatment under 2.01D because she has 1, closely related prior training or experience, and 2, in order to ensure that services are not denied, and she is required to make a reasonable effort to obtain the competence required by using relevant research, training, or consultation. So she's not allowed to be incompetent. She must get the necessary knowledge. Duty of care. All mental health professionals have 2 legally obligating duties: duty of care and duty to protect. This is from Wikipedia. Duty of care. In tort law, a duty of care is the legal obligation that is imposed on an individual requiring adherence to a standard of reasonable care to avoid careless acts that could foreseeably harm others and lead to a claim in negligence. So all mental health professionals, as soon as they take on the patient, they have established a duty of care for that's whether they're doing an assessment or treatment, no matter what they're doing, they're taking on a duty of care for a adherence to a standard of reasonable care. Duty to protect, from Wikipedia. In medical law and medical ethics, the duty to protect is the responsibility of a mental health professional to protect patients and others from foreseeable harm. The foreseeable harm is possible child psychological abuse. Path A is by the targeted parent. Path B is by the allied parent. But we have possible child abuse on the table simply because of the child's symptoms. If you have a child seeking to flee a parent, is that parent abusive? Differential diagnosis is the allied parent is abusive. So either it's a targeted parent who's causing the child's motivation to flee that parent, or it's psychological abuse because it's a shared persecutory delusion. So which is it? But duty to care is active all the time. All these cases. The reported child symptoms, i.e., a child rejecting a parent, a directional change in a primary motivational system for love and bonding, a disorganized attachment, child has no organized strategy to bond to the parent, are strongly suggestive of child abuse by one parent or the other. The cause of a disorganized attachment, i.e., no organized strategy to bond to a parent, is abusive or psychotic range parenting. That's Lyons, Ruth, and Maines. I would refer you to on those. So we know that. If you know attachment pathology, is it an insecure avoidant? No, that's low protest. Is it an insecure ambivalent? No, that's high protest. Both of them are trying to bond to the parent. It's disorganized. The child seeking to flee a parent is no organized strategy to bond to that parent. That's a disorganized attachment. The cause of disorganized attachment, look at all the research literature, the cause of the most severe attachment pathology possible, disorganized attachment, is abusive or psychotic range parenting. So if we have everything's going along in the family and the child's come out with a anxious ambivalent or anxious avoidant or secure attachment out of like early childhood, they have a strategy. All of a sudden they enter a disorganized attachment, no organized strategy to bond to a parent. That is a temporal indicator that abuse or psychotic range parenting has happened. Because you have like normal and all of a sudden it goes disorganized, there's abusive range or psychotic range parenting going on that provoke that, if you understand attachment. Okay, so that should just be on the table as a differential diagnosis, is child abuse. Path A, targeted parent, father abusive. The father is abusing the child in some way, resulting in the child's self-protective efforts to flee the father's care. Path B, allied parent, mother is psychologically abusive. The mother is psychologically abusing the child. DSM-5, V995.51. I'm tired of hearing this. People say this isn't in the DSM. It is. Look, right there. By creating a shared induced persecutory delusion, DSM-5 297.1, delusional disorder persecutory type, and false factitious attachment pathology in the child for primary and secondary gain to the parent or to the mother. DSM-5 300.19, factitious disorder imposed on another. Don't tell me it's not in the DSM-5. It is. I want this assessed to see what the involved mental health professionals are seeing or not seeing with the pathology. The child's symptoms alone should result in a proper risk assessment by all involved mental health professionals from their duty of care, reasonable care, standard 2.01, 2.04, 9.01, and 3.04, and duty to protect obligations, foreseeable harm. Standard 9.01. Psychologists base the opinions contained in their recommendations, reports, and diagnostic or evaluative statements, including forensic testimony, on information and techniques sufficient to substantiate their findings. See also to Standard 2.04, bases for scientific professional judgment. So let's unpack that for a second. The information, Standard 2.04, that's the information to be applied is the established scientific and professional knowledge, Standard 2.04, DSM-5, attachment, delusional thought disorders, personality disorder pathology, narcissistic borderline dark, child abuse and complex trauma and family systems. That's the information sufficient to substantiate their findings. Techniques, the mental status exam of thought and perception for a possible delusional thought disorder. That's the technique and the information that is required, mandatory to be applied as the basis for their professional judgments under 9.01. 2.04, bases for scientific and professional judgments, just directly cited in 9.01a, is psychologists' work is based on the established scientific and professional knowledge of the discipline. That knowledge, the established scientific and professional knowledge of the discipline required for application to avoid foreseeable harm from misdiagnosis and mistreatment, includes the DSM-5 diagnostic system, attachment and attachment pathology, delusional thought disorders, personality disorder pathology, narcissistic, borderline, dark, complex trauma, and family systems. That is the knowledge that is required to be applied. American Psychiatric Association, delusional thought disorders, Bowlby, Ainsworth, Maines, Tronick, attachment, Milan, Linehan, Kernberg, Beck, personality disorder pathology, Vanderkook, Cortese, Herman, complex trauma. Mnuchin, Bowen, Haley, Madonna's family systems therapy. There it is. There's a knowledge that is required it be applied. DSM-5. Please get me a DSM-5 diagnosis so we can see what's going on with the mental health people. Do they see it or not? Or why not? What's going on? Note, the APA Ethics Code is mandatory 2.01, 2.04, 9.01 for all psychologists. It's required. All 2 series standards, such as 2.01 and 2.04, are in the competence section of the APA Ethics Code. Podiatrists are not allowed to do open heart surgery unless they are properly trained in open heart surgery. But now here's again the problem. You will not find a psychologist in the family courts who is competent, 2.01, in attachment pathology, in the diagnostic assessment of delusional thought disorders, in personality disorder pathology, in child abuse and complex trauma, and family systems. So, standard 2.01 C and D become active, mandatory, required for all psychologists, mental health treatment providers, duty of care and duty to protect. That's so. So the compliance with all standards of the APA Ethics Code is required and mandatory. Ethical practice is not optional for a psychologist. Legal analogy, explaining it to the lawyers in this situation, explaining it to you, explaining all legal professionals understand. In the healthcare system, diagnostic criteria such as the DSM-5 or attachment classifications or family systems pathology types, those are analogous to the legal statutes in the legal system. The wording of the diagnostic criteria or the legal statute, by analogy, is applied to the symptoms or the evidence that's collected in the clinical interviews or trials. So the legal system has trials. They collect the evidence and then they apply the legal statutes to the evidence. Doctors conduct clinical interviews, collect the symptom evidence, and apply the diagnostic criteria to the symptom evidence. Exactly the same thing. If the symptom evidence aligns with the diagnostic criteria or the legal statute, then the diagnosis applies. The legal statute applies. And the person receives a diagnosis, a verdict of ADHD or autism or schizophrenia or delusional disorder. So over in the legal system will be your various crime statutes. There were robbery or murder or fraud or something. So they apply those criteria to the evidence and come back with a verdict. In the healthcare system, the doctor applies the diagnostic criteria to the symptom evidence and comes back with a diagnosis. Exactly the same thing. So from the APA, this is the diagnostic criteria for persecutory delusion. Persecutory type, delusions that the person or someone to whom the person is close, such as the child, is being malevolently treated in some way. So do the mother and child share a fixed and false belief, a delusion, maintained despite contrary evidence, that the child is being malevolently treated in some way? That would meet the criteria, and so then that becomes the diagnosis or verdict. The legal system. Does evidence meet the criteria of the legal statutes? The healthcare system. Do the symptoms meet the criteria of the DSM-5 diagnosis? Same exact thing. Advancing to treatment, the remedy, before identifying what the diagnosis is, what legal statute was violated, is like moving directly from the allegations to the remedy without the court verdict or diagnosis for what the legal statutes were that were violated. What's the diagnosis or verdict? You just say, I accuse this person of fraud, and then the court says, okay, we're going to send them to jail. What's the verdict? What's the diagnosis? And it doesn't. Don't get a diagnosis first. Then we base our diagnosis on the treatment. Diagnosis verdict. Is the father guilty of child abuse? How? Or is the mother guilty of child psychological abuse, a shared induced persecutory delusion? We need a diagnosis, a verdict from the doctors. Once we know what the diagnosis or the verdict is from the doctors, then we can move into the remedy, the treatment for that diagnosis or that verdict. When there's no diagnosis or verdict, moving to treatment or remedy without a diagnosis or verdict would be exactly the same thing as sentencing someone for a crime without the court first rendering a verdict on whether and what crime was committed. Does that ever happen in the legal system, where the court holds a trial analogous to clinical interviews by the doctor to gather symptom evidence, and then does not render a verdict but goes straight to the remedy? No, that never happens. Well, guess what? It doesn't happen in the real healthcare system either. The family court healthcare system is another matter, forensic custody evaluations. But in the real healthcare system, it should not be either Dr. A or Dr. B providing the diagnosis. It should be the forensic psychologists in the family courts who provide this diagnostic service to the court every time. But they don't. The forensic custody evaluators withhold clinical diagnostic assessments from parents and the courts and offer only their forensic custody evaluation that takes 6 to 9 months, costs tens of thousands of dollars, and provides no diagnosis. And they do that for their own financial benefit and career status gain. It's financial exploitation of a vulnerable population, pure and simple. But that's the problem everybody's now finding themselves in. Because as a result, the father, the GAL, and the court must now try to cobble together a proper assessment and accurate diagnosis for treatment from outside psychologists who don't work, from outside the psychologists who work in the family courts, leading to the current and past and future difficulty. The psychologists who work in the family courts don't do a diagnostic assessment, so then the parents in the court have to go outside the system, but those psychologists don't work in the family courts. And so the entire mental health system is broken by the forensic custody evaluators. We need to stop that and get back to clinical diagnosis. In the legal system, a verdict from the court is required before moving to the remedy phase. What laws were violated? In the healthcare system, it is exactly the same. A diagnosis is required before moving to treatment, the remedy phase. Are we treating cancer or diabetes? The treatment plan for child abuse by the father is opposite of the treatment plan for child psychological abuse by the mother. And either one requires a child protection response. So, what is the diagnosis verdict from the doctors when the DSM-5 diagnostic criteria, the statutes, are applied to the symptoms, the evidence? That's my question as your consultant. In an effort to resolve the consultation issue in the family courts, I have posted my consultation freely available to YouTube in a diagnosis series of seminars. I would recommend that any and all involved therapists watch the diagnosis series pursuant to Standard 2.01A, C, and D. Okay, they don't need to get a hold of me. Just go to the YouTube, watch it. Diagnosis series. I got a YouTube up there on the DSM-5 diagnosis of family court pathology. I have one up there on diagnosing attachment pathology. I have one on the diagnosis of a persecutory delusion. I have one on the diagnosis of child abuse in the family courts. I have one on the diagnosis of factitious disorder imposed on the child, and one on assessing parenting. So they're there, available to everybody freely on the internet. All you have to do is sit down and commit the time to learning about what you're doing and what the pathology is. I would also recommend that the possible persecutory thought disorder with the mother and potentially with the child be rated by the diagnosing and treating mental health professional using the brief psychiatric rating scale, item 11, unusual thought content. I have one in the diagnosis series about the use of the BPRS. They can watch that. You can watch that. The judge can watch. Everybody can watch how to rate a delusional thought disorder using the BPRS. I would also suggest that the GAL might benefit in her role if she were to watch the diagnosis series seminars. And if the court wished to watch some of the seminars to orient the mental health situation involved, I'd recommend the court or GAL or anyone begin with YouTube seminar on diagnosing attachment pathology. I don't know how much more simple I can make it. So with that is my email to an attorney and parent. I'm a doctor. I'm trying to consult with you. I need a diagnosis from the mental health people. In order to provide a second opinion, I need a first opinion. So mental health people, you're required to kind of like diagnose stuff and identify the cause, use at a professional level. What's your DSM-5 diagnosis and why? I'm going to want it supported. If you don't come back with a persecutory delusion, I'm going to want to know why you didn't. Because the symptoms of a child fleeing a parent, if it's not path A, if the targeted parent's not abusing the child, then it's path B, because that's the only cause of that type of symptom. Okay, so why, if it's not A, then it's going to be B, and if it's A, tell me what the A is so we can put it on a treatment plan and fix it. Because we don't need an abusive parent in the child's life. So let's fix whichever parent is causing the problem. So with that, I'm going to head off to my Sunday here, and good luck to everybody, and we'll talk to you next week.